In this video, I'll explain whether your spouse is entitled to half your business under Florida law, and I'm going to break down exactly how marital assets and business ownership intersect in Florida divorce courts. And by the end of this video, you will learn how Florida judges actually decide what happens to a business in a divorce, the critical mistakes business owners make that cost them everything, and the one strategy that could protect you before it's too late. Now, let me be direct with you. If you own a business in Florida and you're married, this might be the most important video you ever watch, because the answer to this question is not simple, and the wrong assumption can cost you your entire company. And I have a gift for you. I've put together a business owner's divorce-proof checklist specifically for Florida business owners. Click the link in the description below to get it downloaded. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent years helping business owners navigate exactly this kind of high-stakes situation, and what I've seen in courtrooms across the state would keep most entrepreneurs up at night. And let me start with a story. A few years ago, a business owner walked into a Florida courtroom thinking his company was completely safe. He started it before the marriage. He ran it alone. His spouse never worked a single day in the business. He assumed the business was entirely his. He was wrong. The judge ruled that a significant portion of that business was a marital asset. His spouse walked away with the share of the company he built from nothing. So how did this happen? Florida is an equitable distribution state. That does not mean everything gets split 50-50. It means the court divides assets in a way it considers fair. And fair does not always mean what you think it means. And here's where it gets tricky. Even if you started your business before you got married, the increase in value during the marriage can be considered a marital asset. Read that again. The growth of your business during the marriage is potentially on the table. So if your company was worth $200,000 when you got married, and it's now worth $2 million, that $1.8 million increase could be subject to division. That's not a hypothetical. That's Florida law in action. Now, you might be thinking, but I'm the one who grew it. I did the work, and you're right. But the court looks at this differently. The court considers your time, your effort, and your labor during the marriage as a marital contribution. Your spouse supported the household while you built the business. That matters to a judge. So how does a Florida court decide what your spouse gets? There are a few key factors. First, the court has to determine the value of the business. This is where things get expensive and complicated. Both sides will typically hire forensic accountants and business valuation experts. These professionals will analyze your revenue, your assets, your debts, your goodwill, and dozens of other financial metrics. They rarely agree with each other. The valuation fight alone can take months. I've seen cases where the battle over what a business is worth cost more in legal fees than the actual amount in dispute. That's a brutal reality. And second, the court looks at whether marital funds were used to grow the business. Did you reinvest household income into the company? Did you use joint accounts to cover business expenses? Did your spouse contribute in any way, even indirectly, by managing the home or raising children so you could focus on work? All of that counts. Third, the court examines something called active appreciation versus passive appreciation. Active appreciation means the business grew because of your personal effort during the marriage. The growth is marital property. Passive appreciation means the business grew due to market forces or external conditions that had nothing to do with your effort. That growth might remain separate property. The problem is that proving passive appreciation is extremely difficult. Most businesses grow because the owner worked hard, and that hard work during a marriage creates a marital claim. Now, if you're finding this valuable, take a second and hit that like button. It helps more Florida business owners find this information. And if you want to stay informed on topics like this, go ahead and subscribe to the channel. You won't regret it. Now, let me walk you through the mistakes I see business owners make over and over again. Mistake number one is commingling funds. This is the fastest way to turn a separate asset into a marital one. The moment you start mixing personal and business finances, you're creating a paper trail that a divorce attorney will use against you. Depositing business profits into a joint banking account, paying personal bills from the business account, using marital savings to fund business operations, every one of these actions blurs the line between separate and marital property. Here's mistake number two, failing to keep proper records. If you can't clearly document the value of your business at the time of the marriage, you've lost your strongest argument. The court needs a clear picture of what the business was worth before the marriage and what it's worth now. Without that documentation, the court may presume the entire business is a marital property. And that's a devastating position to be in. Mistake number three is ignoring the issue until it's too late. I can't tell you how many people come to me after they've already filed for divorce. At that point, your options are limited. The time to protect your business is before you have a problem, not after. And mistake number four is underestimating your spouse's legal team. Divorce attorneys who handle high asset cases are sharp, very sharp. They know how to trace funds. They know how to challenge valuations. They know how to argue that your business growth was a marital effort. And if you're not prepared, you will be outmaneuvered. So what can you actually do about it? Let me give you the strategies that work. The most powerful tool is a prenuptial or postnuptial agreement. A well-drafted prenup can clearly define your business as separate property. It can establish how future growth will be treated, and it can prevent your spouse from making a claim against the company in the event of a divorce. Now, if you're already married, a postnuptial agreement can accomplish many of the same goals. But here's the catch. These agreements have to be done right. Florida courts will throw out a prenup that's vague, that was signed under pressure, or that wasn't accompanied by a full financial disclosure. You need an experienced attorney to draft it. A template from the internet will not protect you. Beyond prenuptial agreements, there are structural protections you can put in place. Operating agreements for LLCs can include provisions that restrict the transfer of ownership interest in a divorce. Buy-sell agreements can prevent a spouse from obtaining an ownership stake. And these are standard business planning tools, but most business owners never implement them until it's too late. You should also maintain clean financial separation between your business and your personal life. Keep separate bank accounts. Pay yourself a reasonable salary and document it. Don't run personal expenses through the business. The clearer your financial records, the stronger your position in court. And here's something people overlook. Get a business valuation done now, not when you're getting divorced, now. Having a professional valuation on the record establishes a baseline. If your marriage ends 5 years from now, you'll have a clear evidence of what the business was worth before any marital growth occurred. That single document can save you millions. Now let me paint the picture of what happens when a business owner doesn't prepare. You're sitting in a courtroom. Your spouse's attorney is presenting evidence that your company grew 300% during the marriage. They have receipts showing marital funds went into the business. They have testimony that your spouse sacrificed her career opportunities to support the household. The forensic accountant they hired values your company at $5 million. Your attorney is just scrambling. You don't have a prenup. You don't have a baseline valuation. Your financial records are a mess because you commingled everything for years. Now, the judge has wide discretion in Florida, and that judge is now deciding how much of your life's work goes to someone who may have never stepped foot in your office. That scenario plays out in Florida courtrooms every single week, and it doesn't have to be your story, but it will be if you don't take action now. Here's the bottom line. Is your spouse entitled to half your business in Florida? Maybe not exactly half, but they could be entitled to a significant portion of it. The law is not on your side by default. You have to take deliberate steps to protect what you've built. The good news is that tools exist. Prenuptial agreements, clean financial practices, proper business structuring, and proactive valuations can all work in your favor, but only if you use them before you need them. All right, if this video helped you understand what's at stake, do me a favor and hit that like button and subscribe to this channel. I put out content like this regularly because Florida business owners deserve to know how the law affects them before they learn the hard way. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.